The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. We have 3 cases that will be submitted this morning. Those cases are Jacob Schmidt versus State of Iowa, State of Iowa versus Calvin Plain Sr., and the final case is in the matter of M.W. That last case is now submitted to the court without argument, and we'll hear the arguments in the first case. Ms. Lucey.
Good morning. I'm here today representing Jacob Schmidt in his appeal from the denial of his PCR in Woodbury County. Mr. Schmidt may properly seek post-conviction relief after entering a guilty plea. The Court of Appeals incorrectly ruled that his guilty plea waived all future challenges to the conviction. Iowa Code Section 822.21d specifically states any person who has been convicted or sentenced may file for post-conviction relief. Mr. Schmidt asserted in his petition that there exists evidence of material facts not previously presented and heard that require vacation of his convictions in the interest of justice. The plain language of that statute does not prohibit someone who entered a guilty plea from filing for post-conviction relief.
Counsel, do we need to decide whether a guilty plea can be challenged broadly, or DNA or other forms of exoneration or potential challenges, if we can decide this case more narrowly under the statute of limitations?
I think that it goes twofold, actually, because I mean, if you decide that he's not within the statute of limitations, then it doesn't matter whether he could file, challenge his guilty plea or not.
Have we ever held that a recantation is a ground that can be asserted more than 3 years later?
I don't believe this court has ruled that a recantation would be a ground of fact that could not have reasonably been raised within the statute of limitations. But also, if you compare it to a DNA test, that potentially if same type of thing, does the result of the DNA test, is that the ground of fact, or is it the idea that you knew that there was biological material?
Well, the differences trouble me in that we've got a long line of cases that recantations are viewed with suspicion. I mean, in this case, it seems to coincide with the defendant's release from prison. And aren't recantations fairly common in intra-family abuse cases?
And I don't know how common they are, but if you look at the history of this case, in the appendix, there is the envelope where he sent his post-conviction relief application in, and I believe it shows that he is incarcerated, so he was not out.
He was nearing the end of his 7-year sentence, right?
Actually, I believe that his 7-year sentence, he would have been released on that, but he was back in custody on a violation of his special sentence, which had nothing to do related to sex offenses. It was a technical violation. So within that time period, Mr. Schmidt was in custody, and only after I became involved did he get out of custody. And when you look at recantations, if they're viewed with suspicion, and I think that's fine if we want to say they're viewed with suspicion, but that doesn't mean he doesn't get a hearing. And that's ultimately what this is about, is does Schmidt deserve to have a hearing where he can meet his burden of proof and prove his claim? Does his guilty plea waive that? And is the recantation not his claim of actual innocence The recantation is the ground of fact.
So if you win this appeal, what happens next?
He goes
gets
back to district court and has a PCR hearing where he has the burden of proof of proving that he did not commit this crime.
Is there really a distinction between arguing that this is newly discovered evidence as opposed to actual innocence? I mean, aren't they so connected that?
They are, but it's the avenue of how you're getting there to prove your actual innocence. And so each case is going to have a different ground of fact, get beyond the statute of limitations, and a different newly discovered evidence. So if you look at the cases where maybe you have a DNA where it clearly excludes the person who was either found guilty after trial or pled guilty, and we know that people who are innocent plead guilty, because I mean that's just a fact of life. I don't think anybody's going to dispute that that occurs. So if the DNA exonerates the person, that's the ground, that's the newly discovered evidence. If you have a witness that comes forward who has, information that you would not have been able to discover at the time of trial or the guilty plea, that's the newly discovered evidence. And so ultimately what people may be trying to prove on an actual innocence case is, I didn't do it, compared to a technical violation of the law that may result in a new trial.
The problem, is when you have a guilty plea, you don't have a trial now.
Correct.
So if it goes back for a hearing as you request, then we're going to, in effect, have to have a trial 11 years after the fact, right?
Correct, and that's actually what a PCR generally is. And that's one of the difficulties with a PCR, is that it is far removed, and it ultimately
Usually a
trial again.
PCR doesn't retry the case because you have witnesses and their testimony is in the record and there were jury determinations. So it just seems, you open the door now to something that happened 11 years ago. Anytime there's a guilty plea and a victim recants, no matter how many years later, you're going to have to go back and have a hearing, and the state is going to have to attempt to go back and prove up what initially happened. Doesn't that open the door kind of wide?
No, it doesn't open the door wide. I don't see a distinction between that and other newly discovered evidence. So,
But in a trial, the victim testifies that the defendant was the perpetrator, okay? And
generally,
and the defendant was convicted beyond a reasonable doubt, and doing it or not doing it has anything to do with it. If the state can prove beyond a reasonable doubt you did it, you're guilty. In this situation, the only evidence that the state would have of guilt if they had to retry this gentleman was a recanted confession. They have nobody to testify as to the case. So how does the state prove its case the second time around when the witness is no longer in existence?
I think it's the same way as they tried on the first time around. And if you look at this case, there is other evidence that the state may be able to present that his claims are, the recantation maybe should be viewed with suspicion, but maybe not.
Well,
But
Counsel, following up on Justice Wiggins' question, if there had been a trial before, then we'd have the stepfather's eyewitness testimony on the record. And if he wasn't around 11 years later, the state could use that. But the guilty plea, the state, its work is done. And is this a good case for actual innocence when you've got all this other evidence, most notably the stepfather who walked into the bedroom and caught him red-handed?
This case is a good case for actual innocence, not because this record shows that he's actually innocent. It's the idea that if we say a guilty plea prohibits a petitioner from trying to show that he is factually innocent, then we've picked, this guy can do it, but if you have DNA, that's good enough. We're going to let you do it. But either way, if the person is factually innocent, then it is a miscarriage of justice. And should we want, just because it may be difficult and unpleasant, just like any other legal proceeding, the law doesn't preclude it. And so if you start, and it maybe part of it's my fault by saying this is an actual innocence case. That's his claim. But he needs a hearing to be able to present his claim. And if we just say you pled guilty and
Well, I think I agree with Justice Waterman that this, to me, is not a real great vehicle for the actual innocence. And I think I disagree perhaps with what you said earlier, that recantations are the same as actual innocence or as a good vehicle for getting to that, because I see recantations as being really unique, and under the facts of this case, I don't even see how you get to the gateway of actual innocence based upon one recantation. Again, 11 years later, I'm not quite getting it, so I want you to help me.
okay. And I think that there's the difference between what evidence we think is good versus the legal procedure of how to present that evidence. So if the legal procedure is that if he fits squarely within 822.21D, he should get the opportunity to try to present his case. If his case fails, it fails. So what I would ask
But how
this
do you
court-
get under that? I guess that's my question. How do you get under that? A recantation,
is that a
11 years
material
later,
fact?
doesn't really get me to that newly discovered facts or evidence.
Okay, but at the time of the guilty plea, the victim was not saying he didn't do it.
You don't know what the victim was saying because you didn't have a trial. I mean, the victim only says it when the victim gets on the stand and raises their right hand and testifies. And we all know, who's ever tried a case, that sometimes people don't say what they said they're going to say.
And sometimes they don't, but oftentimes they do. So when you're making that assessment to accept a guilty plea, whether you're factually guilty or factually innocent, those are the assessments that go into it. So if we're going to say that, a guilty plea to drugs or a sexual assault where later is proven that it really just did not happen, that there was, this person did not commit the sexual assault, the DNA exonerates him. But if we're going to say, well, you should have gone to trial and the victim might have said, oh, it's not you.
Go halfway. It's not going to make you happy, but it might make the law happy. Can't we say, no, a guilty plea is not an automatic bar, but you need something more than a recantation?
I think that if you can go that way, but I would encourage you not to go that way. Because if you say that a recantation is not, then that precludes anyone in the future, no matter how good that recantation may be. It should be the adversarial process of whether or not you can prove your claim. So,
What does the case law in other states say about recantation and this kind of claim?
well, I think that in the exoneration, or in the Innocence Project brief, there was discussion of some of those cases listed that were recantations. And basically what it was, the holdings are, guilty plea doesn't preclude seeking the claim of actual innocence in the interest of justice.
Here's the problem, I think. I mean, on the guilty plea, it seems to me there's a lot of support for the notion. People plead guilty all the time when
Sure.
they're innocent. And that's in part because of the severe sanctions that they might be exposed to and so forth. And the recent decades have shown through DNA in particular that there's been a lot of occasions where people have pled shown that they were not. So that's on the plus side for you. The more troublesome side, I think, for you is that recantations are rife, and there's a lot of case law, just as there's a lot of case law saying that guilty pleas, aren't really the end-all, be-all. There's a lot of case law saying, well, recantations are somewhat common. And so the real question that seems to me then is, what gatekeeping role does the district court have when recantation claims are made in the context of post-conviction relief? Do you have a mini trial always? Do you have a mini trial sometimes, or a mini trial never? And I understand you saying that never doesn't work.
It doesn't work.
Okay, well, let's say it doesn't work. Just for, does it always work?
If the information in a post-conviction relief raises a genuine issue of material fact, you get past summary judgment like everything else,
Treat it like a pleading, would be your view.
and then you go ahead and you have a hearing. In cases that I can think of, and I don't know the case name off the top of my head, sometimes it's a motion after trial, and a trial where the victim testified, then there's newly discovered evidence that there's a recantation, and the district court hears that. And after hearing it, the court is in the best position to say, I think it passes standard of proof, or it does not. And ultimately, that's all we're here asking for, is that Iowa does have an avenue to claim actual innocence, and that a hearing is required. The results of that hearing, that's up to them. And I'm counting up again. Thank you very much. I'd ask that the court reverse and remand for a hearing.
Ms. Lucey, thank you as well. Ms. Soich?
May it please the court. Good morning, Your Honors, Counsel. Your Honors, we're here today asking you to maintain the longstanding principle that a defendant who pleads guilty is different than a defendant who chooses to go to trial.
Wait, you're not gonna
Plead
really,
put-
you don't
Your
take,
Honor,
you're not gonna take the position that if there's DNA evidence exonerating a defendant, the guilty plea is gonna bar him. You're not gonna take that position.
Your Honor,
can't
I would
imagine.
not take that position, especially because there is, as the court knows, a statute particularly addressing that very
Even if
scenario.
we hadn't had it, you wouldn't really say it was foreclosed, would you?
Your Honor, I would probably assert that this court should consider that a guilty plea is a lid on the box for finality's sake. And, Your Honor, because the defendant has chosen not to go to trial, chosen not to put the state to their burden of proof, a defendant in that situation has, and I could see, Your Honor, you're shaking your head, so I
I am, and in part because there's a lot of case law out there that doesn't go in your direction on statutes just like ours. And the notion that has developed over the last several decades is kind of a pragmatic recognition of guilty pleas. We have youth that plead guilty, we have people of limited intellectual ability to plead guilty, and we have people that have pancaking offenses and so forth. And frankly, the literature now is kind of rife with people who have pled guilty that were actually innocent. And looking at the statute in terms of interest of justice and so forth, it's hard for me to swallow the notion that someone who makes a persuasive case of actual innocence can't get relief under the statute.
I understand that, Your Honor. You would have to overrule all of this court's precedent, though, that says that the guilty plea does waive any defenses not intrinsic to the plea, including the right to challenge the state's evidence. And just because the state's evidence gets better down the line, on the day that the defendant pleaded guilty with presumably the right to counsel, as long as it was a valid guilty plea, then that really is the end of the inquiry for that defendant. Now, I do agree that with DNA, that is certainly the situation where it is the most hard to.
Well, let me change the hypothetical and get it into recantation, because that's what we're dealing with here. And as you know, the law has been skeptical of recantations generally, I would say, or at least judges
I would
have
say
been.
absolutely, Your Honor.
On the other hand, there are cases out there where the recantations are overwhelming, where you have multiple recantations, and then it turns out there's a conspiracy. You know, there's a
The
real
McMartin preschool kind of,
McMartin
yes.
is a good example. My heavens, and it seems to me, I'm pressing you on the margin now, but it seems to me in a case like McMartin, to suggest that there wouldn't be post-conviction relief available in furtherance of justice as our statute is presented, even if there'd been a guilty plea in the background, would be a difficult case to defend.
It would be, Your Honor, but I would say that the interest of justice language in our post-conviction statute, really in 822.21D, is really the newly discovered evidence provision. And this court said that in Harrington and Glendale Moore. In all the newly discovered evidence cases, the court says that that interest of justice provision, it doesn't appear to be some wide open provision that a defendant can make any claim that might impact.
Sure, I mean, there's a piece of evidence that's floating out there that wasn't presented and so forth and so on. It's got, I mean,
So it has to be under the overlay of the interest of the newly discovered evidence.
But it seems to me and there are recantation cases out there where PCR type relief has been granted. Some of them are perhaps on the facts more, shall I say, florid or
Yes.
Detailed. But here's where I'm headed. I mean, quite frankly, and I know you'll push back, but I'm having trouble saying that recantations never open the door for PCR.
Yes, Your
I'm
Honor.
struggling, and I have trouble saying that. If I say that, and if that's where I am, doesn't it mean that the court, based on kind of the pleading, ought to at least entertain it? And it may well be that it's without merit, and we all understand that, I guess. But you've got kind of an absolute position, frankly, on both prongs. I think you have an absolute position on guilty pleas, and you got an absolute position on recantation. And I'm pushing back now on recantation, the absolute position.
And Your Honor, the absolute position is based in part, I think, on the importance of the finality of the guilty plea and the
But
way
you
that
wouldn't
our
really
system
say
works.
an actually innocent, I mean, would you really take the position that an actually innocent party who, and this is a hypothetical, I'm saying McMaster's, I'm going off on, it turns out there was a conspiracy, and it turns out that there were all kinds of adverse testimony at trial that was totally bogus, and we have affidavit A, B, C, D, E, F. You'd say, well, finality, you pled guilty, rest of your life in prison. I don't think you ought to take that position.
Your Honor, I don't think that we'd have to take that position completely, but I think in terms of the PCR statute in Iowa and whether the PCR statute is the vehicle through which to make that claim, I think that is the state's primary position, that only in the limited context of a guilty plea and a recantation and the post-conviction statute, and of course, defendants can challenge their guilty plea by alleging ineffective assistance of counsel that rendered it involuntary or unintelligent always, but
that doesn't work when 10 years from now, the evidence comes around that wasn't available. People, my understanding of the law is that whether you did it or not is not really important. It's whether the state can prove you guilty beyond a reasonable doubt. And defendants are faced with sometimes overwhelming evidence that may be bogus, may be tainted, but they don't know it. They plead guilty because they get a better deal or they get less time. And then it turns out 5 or 10 years later, like in Chicago, all these confessions and all these witnesses were coerced into testifying, and people are being let out left and right in Chicago over this, in Illinois. But what is the problem with the state at least giving the defendant a chance to prove their case? Just because you allow them into the door doesn't mean they're going to go out the back door.
no, Your Honor, but our position is that you don't have to allow them in the door when they waived the right to challenge that evidence initially. And in the guilty plea context, they have waived the right. That's considered the end of the ability.
If you don't have any way to show that evidence in the first place was bad, DNA is an easy example because DNA has become more sophisticated. But if you don't have any evidence to prove that evidence that you're looking at to go to trial is bad at the time, but you discover later it is bad, what's the problem with letting a truly innocent person or a person who did not commit the crime or a person who the state cannot prove beyond a reasonable doubt they did it from at least attempting to vindicate themselves?
Well, Your Honor, a truly innocent person is not this defendant, I would hasten to add before I address the rest of your question. This defendant is not someone who really is in a good position to extend a claim of actual innocence because, again, the state...
But that's the merits. Let's assume this guy was one of these
It's actually-
guys who was actually innocent. What's wrong with letting a person at least go through the court proceedings to have that determination? I sort of agree with you. I don't know how this guy's going to win, but that's besides the point. We're talking about a procedural issue. We're not talking about a substantive issue.
This court, Your Honor, time and time again, in Alexander, in Matley, in Antonucci, in the court's cases dealing with newly discovered evidence in the context of a guilty plea, has said, and in Alexander, the court actually said the phrase, notions of newly discovered evidence simply have no bearing on a defendant's knowing and
But
intelligent
we've been wrong in the
guilty.
past.
Well, you have been wrong in the past, Your
I mean,
Honors,
you
but
come here
I
all
don't
the
think you're
time. The state comes here all the time and tells us how we've been wrong in the past.
You're not wrong in this instance, Your Honor, because really, the whole system depends on this idea of finality and holding the defendant to his choice. Again, the DNA example, clearly the most heart-tugging, I think, and we do have a statute that specifically exempts defendants who
Ms.
plead.
Solich, you know, we're talking about this underlying rationale for our rule of finality, and when we adopted it, I think we had a greater sense of confidence that finality had a strong sense of justice attached to it, and that's the argument that you're making to us today. But don't you think we've learned something about finality that kind of undermines at times our confidence in justice, and that we need to consider that and incorporate that as we try to apply that rule now?
Your Honor, we may have learned something about finality in a general sense, that finality is not an at-all-costs kind of proposition. But I would urge you to find that in our state, in Iowa, principles of finality are probably more applicable because of our guilty plea process. For instance, as the court is aware, I'm sure, not all states require a factual basis. Iowa is very stringent on its requirement of a factual basis for a guilty plea, and this court takes a very dim view of the circumstance where they deem a defendant to have pled guilty to a crime that he did not commit, and indeed finds per se ineffective assistance if a lawyer allows his client. So I think when you look at other states, Idaho, Ohio, New York, there are a host of other states that don't require a factual basis, and there's sort of a wink and a nod in the guilty plea proceeding. Here, we do not have a wink and a nod proceeding. We have a factual basis requirement. We have a finding of the colloquy, of course, of 8(2)B. We have a requirement that the court find that it's knowingly and voluntarily entered.
Well, are we talking about two different concepts then? That are we talking about, first of all, identifying that there may be a need for a process to ensure that justice is woven into finality, and then try to decide which cases are deserving of that process? Is that where we're at?
Perhaps, Your Honor, but I think that in Iowa, we have at both the front end and the back end procedures in place to protect defendants who are actually innocent from pleading guilty. Again, in the initial instance, the factual basis requirement, which this court has applied very strictly. In the back end, we have the knowing and voluntary ineffective assistance claims. But also, Your Honors, I should note that post-conviction relief should not be considered the only way that a defendant can present a claim who is actually innocent. Again, in the DNA statute, 8110, the court specifically exempts, or not exempts, includes defendants who have pled guilty, and says, so the lid is off the box by the legislature in that case. Even if you have pled guilty, if DNA exonerates you, you may have the opportunity to have that DNA presented. But, Your Honors, importantly, I think, in the DNA statute, 8110 sub 9 talks about the fact that the DNA evidence, the exculpatory DNA evidence, should be given to all of the parties involved and the appropriate agencies, and then used in consideration in light of pardon, reprieve, commutation, or parole. Your Honors, then even in the DNA statute, there is not, and I thought that this was really interesting when I looked at this, there's not a provision that you go through the post-conviction chapter once you get the exonerating DNA evidence. It says, in light of, so I would urge the court to realize that the executive branch remains a branch that could step in a case of true injustice. If it's DNA, we have 8110.
How many occasions have there been of that in the last 10 years?
Well, in the last year, Your Honor, the governor pardoned 5 individuals. So I don't think it's unheard of.
Is your argument that by establishing this DNA safety valve, the legislature recognized that under 822 you're ordinarily barred,
Yes, Your Honor.
and that
Yes,
we
Your Honor.
would be implicitly overturning what the legislature did?
At least as to the DNA, Your Honor, yes, that is my argument.
Why is it that the cases in other states go the other way? And I'm talking about Rhode Island, Colorado, South Carolina. They all have virtually identical statutes, I think, with the
They do,
you know,
Your Honor.
little bit.
They
you know.
do, but I would point you to Indiana. I think the Norris case in 2008 has that exact same language that we do in 822 2D1. And in the Indiana Supreme Court says, no, a guilty plea does end the inquiry as to newly discovered evidence. Also, the Supreme Court of Utah goes the other way. So, Your Honors, I think you can find either.
No authority both ways. What about the cases that deal with recantations? There's quite a few of them out there, and there's recantations even in the sexual, I mean, kind of.
Mostly in the sexual
Yeah.
area, Your Honor.
You know, perhaps somewhat close to ours, our situation. Bottom line is, it's not uncommon, I would say, to have recantations successful in post-conviction relief, although the vast majority are unsuccessful.
That's right, Your Honors. I think the vast majority are unsuccessful, whether the court looks at due diligence, it was available before, it's simply not credible.
Sure, and I got to tell you, you got me on that point. I mean, as a general matter, I would say there's lots of case law. Recantations are dime a dozen. They often come from prison settings and are suspect.
Viewed with the utmost of suspicion is what this
And I
was.
get that. However, that's a factual determination.
Your Honor, I see that my time is up.
Counsel, before you sit down, I have one inquiry I'd like to just run by you. We've used in this case, in the brief, characterizations such as lid on the box, and the chief has asked you about the system's interest in finality. Aren't those concepts really, both of them, really proxies for the notion that we are afraid of the floodgates of challenges to pleas? And if that is an accurate analogy or alternative characterization, you want to make the case for the floodgates fear?
Well, Your Honor, I think that the floodgate certainly is part of the analysis, that if we allow defendants who have chosen to voluntarily and knowingly plead guilty to then later take it back by saying now there is new evidence, and this court has time and time again also said, just because there's information that affects the calculus of how good the state's evidence is, that doesn't mean that you get to take back the guilty plea. That doesn't affect it. It's not intrinsic. But let's say that the floodgates is one problem, certainly. But also the other finality indications in terms of just rehabilitation in the efficient administration of the system, in allowing a sense of repose, as the court always says, in our criminal justice system, in letting the victims believe that their case has been settled, especially when someone has solemnly stated in open court, yes, I did this, and the court has found that there is a factual basis. I think the floodgates is just one part of the idea that finality is critical to our system.
You answered my concern in part, but with the chief's permission, I'd like to follow up. You mentioned the victim, but here we have the victim saying it didn't happen. What about the middle ground? What are the practical consequences if we say there's a question of fact precluding summary judgment dismissing this PCR? You go to a hearing, and I'm thinking of a lot of our recantation claims came up right after on a motion for new trial, and the trial judge, who had heard the trial testimony, then listens to the recantation and says, I'm not buying it. I think the trial testimony is better. What if we had a mini trial here and had a judge decide whether this 21-year-old is telling the truth on his recantation or was maybe just fearing a big bully half-brother coming after him, and then when examined in a courtroom says, nah, I retract my recantation.
I mean, you could do that, Your Honor, but I don't think it's warranted to have the mini trial, especially when we do have the passage of time, 11 years later, however many years later, and especially when with recantation, again, we've said it a couple of times, but there is no other evidence that this court views so suspiciously. We view it with the utmost of suspicion, and then we add in the fact that it's a child sex abuse case, that it's inter-family sex abuse, that the affidavit itself, he says, now that I'm a full adult, I want to tell my brother I'm sorry and see him. Your Honors, it shouldn't really even open the door, I think, to a factual inquiry when we discount recantation so strongly.
Is the recantation a ground that couldn't have been asserted, timely or within 3 years of the conviction?
Well, I guess that depends on who you believe. In this case, he says, I didn't tell anybody until I turned 21, but there are other cases certainly which look at the idea that if you're actually innocent and you know that you're actually innocent, and here this defendant certainly knew, Your Honor, whether he was attempting to anally penetrate his little brother that day, he absolutely knew that. He knew that more than anybody else in the entire case or the system knew that. So if he really knew that this was not true, he could have pursued that recantation or at least asked his little brother, presumably, or had
Well,
someone.
we don't know any of that. I mean, you may be right, but at this stage of the game, we only have a pleading.
Right, Your Honor, but other cases have said that when you maintain a claim of actual innocence and there is recanted testimony, that you could have gotten that recant testimony through your own pursuit earlier. I know that's not always the case, but the cases do indicate that, and a lot of times that's how they dispose of the recantation. Your
Thank you.
Honors, we ask that you affirm. Thank you.
Thank you, Ms. Solich. Rebuttal, Ms. Lucey?
Justice Apple, in response to other recantations, if you look at the case State versus Fontaine, it's cited in one of, I think it's in the Innocent Project brief. It's from Rhode Island where there was recantation and with other evidence that raised suspicion about the factual assertions. Fontaine was granted a hearing, and that's all I'm asking for is the right to have a hearing.
Well, let me, I guess here's where my concern is, and I'm not into absolutes either, like I don't believe most of the members of the court will be into absolutes that you can never do it. But in this case, you've got unique recantation, and I'm not as familiar with these other cases where it could be just the victim who recants. Here we have another eyewitness to the events here. And to me, that adds a lot of weight to the district court's ability to weigh the evidence and then to summarily have it. I don't know that it's necessary that you have more than what you had here, which was a summary judgment on the record that's available. You have one person, the victim, who recants, and maybe you can illuminate me a little bit about all these other cases. It's a whole different story to me if 7 years later the victim comes back and he or she is the only victim here, the only eyewitness here, and then they say, well, this didn't happen, and I'm sorry and I want to recant. I can see that maybe requiring a full hearing then to go back and figure out what all the other evidence that was involved in the case. But when you have a separate eyewitness who would have come in and testified exactly what the minutes of testimony said, why is this process wrong under the facts of your case here?
And I think that there's several things here. The district court granted summary judgment on the idea that he was precluded from seeking PCR because of a guilty plea.
And I agree with
District court
that.
didn't make any factual
I agree with the
findings.
rationale there. I'm just trying to play it
And
all
so
out.
if you play it all out, and if the district court wanted to say, I find that there is no genuine issue, genuine material issue of whatever, however it goes, then the defendant or the petitioner would have to be on notice that the court's going to actually rule on the merits, which didn't happen. And so we have minutes of testimony with police reports that says the stepfather would testify to this. But you also have indication that Mr. Schmidt said, I didn't do it, and there's some animosity between Schmidt and the stepfather.
Well,
So
let me-
there may be reasons that requires a factual finding.
Maybe, but let me ask this. Your case would be different if you had recantation from the victim and a statement from the stepdad saying this didn't happen.
And maybe that would be a
No.
better case, but is
No.
that required to get past summary judgment?
Well, and then looking forward to the trial based on the pleading. Supposing you proved, you had the witness get up and say, I recant. Record's closed. That probably isn't enough, right?
And unless the district court thinks that that
I
DC
think it's
is
highly unlikely to be
incredibly,
enough.
persuasive.
So have you, I mean, there might be a question as to whether you've actually pled sufficient facts.
But that's not the ruling here.
Yeah, but following up on Justice Appel's question, is it your position then that whenever there's a guilty plea, no matter how many years have passed, if one person identified in the minutes of testimony recants what they're reported as saying in the minutes, you get an evidentiary hearing?
And I think my answer to that is no, not necessarily.
And
because you
what
still-
is where do you draw the line?
You still have to have that nexus between what your newly discovered evidence is and the outcome of the case. You know, Harrington says that, but if you plead that nexus, and that there's a sufficient nexus, Harrington says, we don't rule that it has to be beyond a reasonable doubt. It's a factual situation that the judge has to find after evidence. So if you have a recantation that, doesn't necessarily affect the outcome looking at the rest of the evidence.
But how do you judge that without a hearing when you never had a trial?
Well, I think that's probably difficult, but that's exactly what the court does in a summary judgment,
But
is whether or not this works.
Counsel, does this record satisfy the federal standard for actual innocence, which I think would require us to find that, quote, no juror acting reasonably would have voted to find him guilty beyond a reasonable doubt in light of this recantation? But given the stepfather's eyewitness testimony, doesn't that suggest that a jury could still convict even without the victim's testimony?
And the federal standard is a procedural bar, basically, that you have to have the claim of actual innocence to get you past the procedural bar, but then you still have to have a constitutional violation. The Iowa statute does not have that innocence gateway like the federal courts do, so our law is different. I'm past my time, but I would like to leave you with one thought. One of the best things I've ever heard to try to explain PCR and direct appeal to clients is that the direct appeal is a closed box. You cannot open it, you can't take stuff out, you can't put stuff in. But the PCR is an avenue where you open that box up and you can add to it. And that's all that Mr. Schmidt is asking, is that he be given an opportunity to add to that box and be able to present his claim. Thank you.
Ms. Lucey, thank you as well. Schmidt versus State is now then submitted to the court, and we'll next hear the arguments in State versus Plain.